I know that you've talked about a lot of the issues that I wanted to bring up, but Professor Britt and Mr. Paniccio, I'd like to turn to talking about the Administrative Procedures Act and vacatur. And one of the provisions of the Judicial Relief Clarification Act, which I am proud to be a co-sponsor of, amends Sections 705 and 706 of the APA to limit relief to the persons before the court. My question to the two of you is, can you discuss the emergence of the APA vacatur and in the broader conversation surrounding universal injunctions and the importance of addressing that issue in any legislation that addresses the universal injunction problem that we have before us today?
Gladly, Senator. So the Administrative Procedure Act allows challenges and judicial review of agency action. And there is a vigorous debate among scholars about whether the Administrative Procedure Act should be understood as allowing a separate remedy of vacatur. I don't think there is such a remedy of vacatur. There's no traditional remedy called by that name. You won't find it in remedies casebooks or treatises or anything else. But there's a vigorous debate about that. What I don't think you can really debate is the interaction between vacatur and universal injunctions. So one of the things that we've seen, especially in the Biden administration, is litigants and courts were shifting from universal injunctions to vacatur, especially as appellate courts and some of the concurring opinions from the Supreme Court started to express more skepticism of universal injunctions. And that kind of switch is really important for a legislative solution. It means a legislative solution has to tackle the vacatur problem as well. Otherwise, you're just going to play whack-a-mole, and you're going to stop universal injunctions, and all the same things will be done by courts against agencies, at least, under the APA.
Thank you.
Thank you, Senator. Professor Britt is the expert on the history of this. I will just say that, as he has said, the issue of nationwide injunctions or vacatur is, they're one and the same. At the end of the day, it's the court granting relief to parties not before it. There is the issue of the set-aside language in 706, and I think any legislation that's going to address the issue of non-party relief needs to take that on. To just take on injunctions would then, in most cases, allow courts just to say, well, I'm going to look over here to the APA and do the same thing.
Okay, thank you. Professor Britt, I want to get your response to some of the criticism we've heard for those that are opposed to curtailing universal injunctions. Let's start with the criticism that we shouldn't eliminate universal injunction because it could lead to inconsistency and an inconsistent application of the law around the country, or in some form of, as you have called it, disuniformity. As you've written about, it seems to me that the question is not about whether we have uniformity. It's more a question about at what level our legal system and our court system is such nationwide uniformity actually achieved. And so the process to get there and how we achieve that, I think, is kind of what is at question. What's your view on the question, and what's your response to the disuniformity criticism of limiting universal injunctions? And relatedly, is disuniformity an inherently bad thing?
So I think there's a lot of value to uniformity in the law. The question is how and when and who gets you there. And in our legal system, we get uniformity, but we get uniformity over time. And I think one of the striking things that you see for universal injunctions is they are proceeding on a premise that the first judge, selected with highly intense forum shopping and in a time of high judicial polarization, that the first judge who takes the question is going to be right. But often universal injunctions get reversed or narrowed on appeal, and so there should be no presumption of the first judge to tackle the question is the one who should get us to uniformity. Instead, the right way to get to uniformity is through appellate precedent, which, as Justice Kagan said, is the normal process.
Absolutely. Well, thank you so much for your time.
Thank you.
Thank you, Senator Britt. Senator Klobuchar?
Yep, just two more questions here of you, Professor Vladeck. Federal judges, we were going through NIH and what that would mean if you had to have an individual case in every single grant in every single jurisdiction of the country, which is why we have this ability on the nationwide front. Let's look at something else. Federal judges blocked the administration's funding freeze that jeopardized everything from community health centers to child care to infrastructure to support for law enforcement. Can you talk about the impact if those judges had not been able to issue a nationwide injunction, including on non-parties?
Sure. I mean, I think we would have seen, Senator, overnight, tons of entities that depend upon those federal funds to provide vital services to everyone, just having to close up shop and not being able to provide those services because they don't have the money. And so, Professor Bray is right that the question is uniformity at what point. I think part of what has not been fully explicated in our conversation this morning is that one of the justifications for uniformity earlier rather than later is irreparable harm. And is the notion that but for this kind of relief at this early juncture, Mr. Panuccio has been attacking TROs for most of this hearing. TROs are based on the idea that the harm the party is facing is so urgent that there's not time for the ordinary process. And I think we really haven't done a lot this morning to talk about how these policies are harming people in ways that create, to me, extraordinary justifications for these kinds of judicial interventions.
Okay. Last one. Judges have blocked the administration's plans to empower Elon Musk to rummage through American Social Security information. My words, probably not the words in the law. And get access to their bank accounts, tax returns. This is all the Doge-related looking at things. If judges had not been able to issue a nationwide injunction, what would be the impact on the American people?
I mean, again, it's different story, different facts, same problem, right? Which is, you'd need retail litigation by, every American whose Social Security information has been compromised, or you would need to somehow overcome the insuperable barriers that the Supreme Court has created for class certification. And so, I don't mean to beat a dead horse, Senator, but it seems to me that those who are averse to nationwide injunctions, but not to the notion that the federal government should be acting within the confines of the law, should actually be supportive of reforms that would strengthen the nationwide class action as a procedurally proper and historically precedented device for restraining the executive when the lawlessness is on such a wide scale.
Thank you.
Thank you.
Thank you, Senator Klobuchar. Ranking Member.
I want to ask a question of Mr. Panuccio, and I think you addressed this earlier, and I want to make sure there's clarity